The Shotgun Booby-Trap Legal Case. Edward and Bertha Briney were sick and tired of people repeatedly breaking into an unoccupied house they owned, despite the copious number of no trespassing signs and attempts made to board up the house by the couple. Over 10 years, they had suffered multiple break-ins and eventually decided enough was enough. Edward Briney subsequently set up a shotgun that was rigged to fire, without warning, when the bedroom door to the house was opened. Opportunist Marvin Katko was the unlucky victim of the trap. Having broken into the house before, he made another trip with an accomplice, accumulating the Briney's belongings until he reached the bedroom door. Swinging it open, he was promptly shot in the leg and sustained what was defined in law as serious bodily injuries. Unbelievably, Katko demanded his medical and legal expenses be paid by the homeowners. And when was refused, turned around and not only sued the Brineys for a whopping $200,000, but actually won a judgment against them for $20,000 in actual and $10,000 punitive damages. The audacity of some people. After Katko was awarded the money, the Brineys appealed the case, and it was taken all the way to the Supreme Court, who upheld the judgment. The case became a landmark in law and is still studied to this day. In 1957, Bertha Briney came into a windfall when she inherited her parents' farmland in Mahaska and Monroe counties, which included an 80-acre tract where the house in question was situated. Over the next 10 years, the Brineys gave up caring for the house, which was described in court records as dilapidated. Instead, they boarded the windows, threw up 7 no trespassing signs across their properties, and dealt with a series of break-ins and vandalism that slowly increased their anger. They even testified that they had complained to the sheriffs of the 2 counties on numerous occasions and were met with a complete lack of assistance. Finally, on June 11, 1967, Edward said enough was enough, admitting on record that he was mad and tired of being tormented, and set up his now infamous 20-gauge shotgun trap. Briney secured his shotgun by attaching it to the iron bed in the room before rigging it with a wire that was wrapped around the doorknob and would pull the trigger on the gun when the door was opened. In court, Edward Briney not only admitted he understood the power of his choice of gun, but that he initially positioned the weapon so it would hit the trespasser directly in the stomach, which would severely injure, if not kill them. Savage. Luckily, Bertha Briney had a tad more compassion and suggested he rejig the positioning so it was towards the floor and would hit someone in the legs or miss them entirely. This is where the evidence conflicts with what the Brineys claimed at trial, which was that the intention was for the gun to scare the person and hit the lower part of the door. Unfortunately for Marvin Katko, that wasn't quite the case. The 28-year-old admitted in court that he knew the house was unoccupied and had even stolen from it before. But when he and his companion, who funnily enough was also named Marvin McDonough, aged 24, entered the house, they certainly didn't expect for either of them to leave with a gunshot wound, especially as they claimed they were just looking for some old glass bottles and fruit jars. Although papers at the time largely reported Katko as injured above the ankle, the truth of his wounds were quite a lot more serious. According to his doctor, Katko suffered a permanent deformity, with most of his leg, including part of his tibia, being blown away. He spent 40 days in hospital, and at one point his doctor considered amputating his leg. While he was able to save it in the end, Katko endured a long recovery and suffered permanent loss of tissue and shortening of his leg. While Katko was charged with breaking and entering to the tune of $50, it was the Brineys who came out of the whole ordeal a lot worse. The initial judgment for $30,000 was issued by the district court, much to their immense shock. In 1970, the Brineys had still not paid what was owed, and as a result, their land was to be sold so as to pay the debt. Which is when their friends stepped in, raising enough money that the Brineys were able to appeal to the Iowa Supreme Court. Unfortunately, the outcome wasn't in their favor and the decision was upheld in law. $17,000 to $20,000 was dropped by Katko in 1976 when the lawsuit was settled. Now an infamous case taught in law school, the fundamental nature of the debate surrounding this case still continues. As the Attorney General Turner said, "You can't be setting a spring gun. We have a good and clear law on that." But with no help from law enforcement and Katko admitting to committing a criminal act, law students frequently argue out the logistics and morality behind the ruling some 50 years ago. In fact, in an interview later in life, the lawyer who acted on Katko's behalf, Gerald Heslinga, interestingly admitted he didn't want a jury at the Supreme Court case, and it was something demanded by the Brineys. The lawyer claimed it was because he saw it as a legal case and believed any judge following the law would rule in his favor. However, what's missing from that explanation is the most likely reason he didn't want a jury, which would be the human element of those not versed in law seeing and sympathizing with the Brineys and their actions. Luck was on his side though when 12 women were appointed. Heslinga believed this was part of the reason the case was upheld, as Katko was described as attractive and charismatic, still sporting visible wounds 3 years later and making no attempt to justify his actions. The usual argument in this scenario would be the case of self-defense, that a person has the right to protect themselves. It's a defense based on justification, but in the case of Briney versus Katko, this argument was invalid as the 4 elements that would allow the Brineys to use the self-defense were not present. They were not confronted with an unprovoked attack, nor was the threat of death or injury imminent, and they did not have reasonable fear that they would be injured or killed if they did not set up the booby-trap shotgun. Finally, the degree of force used was hardly comparable to the offense. It was still argued, though, that an owner has a right to defend their property, especially in cases when law enforcement has not helped. It was just a matter of what level of force was acceptable in said situations. At the end of the day, it came down to simple legality. As per the Handbook of the Law of Torts, law has always placed a higher value upon human safety than upon mere rights and property. It is the accepted rule that there is no privilege to use any force calculated to cause death or serious bodily injury to repel the threat to lands or chattel. There have been many other cases where the courts have ruled similarly. In 1873, in the case of Hooker v. Miller, the plaintiff was also injured by a spring gun on a vineyard when stealing grapes and was subsequently awarded damages. And in 1951, in the case of Allison v. Fiscus, the Ohio Supreme Court also awarded the plaintiff damages when planted dynamite exploded during a theft attempt, injuring his leg. Fundamentally, these other cases and the arguments outlined here are what makes this such an interesting case, and the reason it made its way into torts law books in 1984. But that wasn't even the end of the Briney v. Katko saga. In a strange turn of events, Katko and his lawyer, Heslinga, ended up assisting the Brineys in a case against someone who had promised to help them during the original trial, but instead acted against their interest. And then later, when Bertha Briney sued Katko in an attempt to recoup some of the couple's losses, Heslinga represented Katko again. Strange laws and lawyers made this a landmark case, but one thing that didn't make it into the textbooks was Heslinga's thoughts when Marvin Katko first approached him, which was, "Damn, this will be fun."